Welcome friends. This is the third video on law of evidence, and in this video we will be discussing about section 1 and section 2 of the Indian Evidence Act. Friends, section 1 is extremely important from examination point of view. First of all, we will give a reading to what the section 1 of Indian Evidence Act states. The title is short title, Extent and Commencement. This act may be called the Indian Evidence Act. So this part, that is, this act may be called the Indian Evidence Act. This is what is that provides the title of the act. Secondly, it extends, so it provides the extent. So our title we have already seen. It provides the extent. It extends to the whole of India and applies. It also provides the application. And it applies to all judicial proceedings in or before any court, including court martials. Friend, many a time it has been asked that whether the Indian Evidence Act is applicable on court martial. So it's very clearly it is written including court martials. However, there are certain exceptions other than court martials convened under Army Act, Naval Discipline Act, or the Indian Navy Discipline Act, or the Air Force Act, but not to what all it doesn't applies to, and not to affidavits presented to any court or officer, nor to proceedings before an arbitrator, and it shall come into force on first day of September 1872. So this first day of September 1872 is what which provides the commencement. So broadly speaking, section 1 of the Indian Evidence Act provides us the short title, the extent, the commencement, and the application of the act, where all it is applicable and where all it is not applicable. So first of all, let us see the application part of it. So the section 1 states that it applies to all judicial proceedings. Friends, it's not all proceedings, it's only judicial proceedings. So we have to understand as to what are judicial proceedings, which proceedings are called judicial proceedings, how a judicial inquiry is different from administrative inquiry. Section 2, Clause I of Criminal Procedure Code has provided the definition of judicial proceeding. It states that any proceeding in which evidence may be legally taken on oath. So evidence may be legally taken on oath are called judicial proceedings. Now, what is the basic difference between a judicial inquiry and an administrative inquiry? The basic difference between judicial inquiry and administrative inquiry is that administrative inquiry is limited to fact finding, while judicial inquiry includes a discretion to give a judgment. So we can say that judicial inquiry is a bit broader than administrative inquiry in the sense that administrative inquiry is limited to fact finding. There is no discretion, there is no judgment to be given. While in judicial inquiry, it includes fact finding, discretion, application of discretion, and a judgment to be given. Now, certain examples which have been asked time and again in examination, that whether these proceedings are judicial proceedings or not. So execution proceeding, if we say, it has been held to be a judicial proceeding. At the same time, contempt proceedings are not judicial proceedings. Similarly, proceeding before Income Tax Act has held to be not to be a judicial proceeding, while proceedings before industrial tribunal have been held to be a judicial proceeding. My dear friends, remember it because many a times it has been asked as such. So if we see judicial proceedings are those where evidence may be legally taken on oath. Now, another thing is that affidavits, as we saw that the as far as the application of Indian Evidence Act is concerned, it applies to all judicial proceedings in courts or court martials, except for the court martials conveyed under Army Act, Naval Discipline Act, or the Air Force Act. Now, another thing where it is not applicable is affidavits. So it is clearly stated in section 1 of Indian Evidence Act that it is not applicable on affidavits. This is because the affidavits are prepared or based on personal knowledge and belief of the deponent, and it is very difficult to cross examine based on it. Then, but there are certain exceptions to it. One of the exception is that those which are provided under Order 19 of Civil Procedure Code. Under Criminal Procedure Code also, Section 295 to 297 provides certain exceptions where affidavits are taken to be as evidence. Now, next question is regarding arbitrators. Does the Indian Evidence Act apply on the proceedings before an arbitrators, or are arbitrators proceeding included in the application? The answer to it is also no, and that is very clearly provided in section 1 itself, but not to affidavits presented to any court or officer, nor to proceedings before an arbitrator. So very clearly section 1 states that the proceedings before an arbitrators, the Indian Evidence Act is not applicable. Hence, in those cases, principle of natural justice is applied. This was held in Municipal Corporation of Delhi versus Jagannath Ashok Kumar. That in arbitrators proceeding, principle of natural justice is applicable and not the Indian Evidence Act. Now, what about tribunals? Are the provisions of Indian Evidence Act applicable on tribunals or not? So it has been held that on tribunals also the Indian Evidence Act is not applicable. Just like in arbitrators proceeding, what is applicable here is principle of natural justice. Next is a concept called Lex Fori. Lex Fori means law of the forum. Some laws are there where the rules, the laws which are applicable are the laws where the proceeding is going on. Now, Indian Evidence Act is a Lex Fori. Indian Evidence Act is a Lex Fori. Remember it, friends. This has been asked in preliminary examination many a time. It is law of the forum. Now, what does this law of the forum mean? Law of the forum means that suppose the proceedings are going on in an Indian court at Patna, and some evidence is to be recorded in London, in England. Now, while the evidence are to be recorded in London, will the English common law be applicable while it is being recorded, or will the Indian Evidence Act will be applicable? Now, Indian Evidence Act being a Lex Fori, that is law of the forum, the laws which will be applicable are the laws where the proceedings are going on. That is the laws which are applicable in India. So please remember, friends, it is a Lex Fori. Now, Again, we will see two things. I will like to emphasize once again that short title. Short title is that it is Indian Evidence Act 1872. And commencement, we have seen the commencement to be the first day of September 1872. Many a times in many competitive examination, this has been asked that what is the date of commencement of Indian Evidence Act. So friends, it is 1st September 1872. Now, extent. As I told you, the section 1 provides the extent of the Indian Evidence Act, and it says that it extends to whole of India. So we saw under section 1 that it provides short title, extent, commencement, and application. The short title is that it is called the Indian Evidence Act. Extent, it extends to whole of India. Commencement, it commenced on first day of September 1872. Then application, where all it is applicable and where all it is not applicable. We saw that it is applicable on all judicial proceedings before any court, including court martial. And where it is not applicable on court martials conducted under Army Act, under Naval Discipline Act, Indian Navy Discipline Act, and Air Force Act. Besides this, it is also not applicable on affidavits presented to any court or officer and not to a proceeding before an arbitrator. Similarly, as we also saw that what is judicial proceedings, as it is defined in section 2 clause I of CRPC, that those proceedings where evidence may be legally taken on oath. The difference between judicial inquiry and administrative inquiry, that administrative inquiry is limited to fact finding, while judicial inquiry involves certain discretion and judgment to be made. Execution proceedings have been held to be a judicial proceeding, while contempt proceedings are not. Proceedings before income tax tribunal are not judicial proceeding, while proceedings before industrial tribunal have been held to be judicial proceedings. Affidavits, on affidavits, the Indian Evidence Act are not applicable. However, there are certain exceptions. For example, Order 19 of Civil Procedure Code and Section 295 and 297 of Criminal Procedure Code. Similarly, we saw that it is not applicable on the proceedings before arbitrator. What is applicable on them is principle of natural justice, which was held in case of Municipal Corporation of Delhi versus Jagannath Ashok Kumar. Thereafter, we saw that as far as tribunals are concerned, they are also as arbitrators, that Indian Evidence Act is not applicable and principle of natural justice is applicable in their case. Then it is a Lex Fori, that is law of the forum. Those laws are applicable where the proceedings are going on. Short title, commencement is 1st September 1872 and extent whole of the India. Now, section 2, it is to be remembered that section 2 has been repealed by repealing act of 1938. Sometimes they may ask this question that section 2 of Indian evidence has been repealed in which year. Please remember it is 1938. That's all for this video. In the next video we will be dealing up with section 3, which is the interpretation clause. Thank you.